Hi, Attorney Steve Vondran, licensed to practice law in California and Arizona. We are a civil litigation law firm and I'd like to talk today in this video about citing to unpublished opinions. Okay, so let's talk about this. It's a very important topic. It's not legal advice. Some of the information in this video may be inaccurate or outdated. Do your own research, but let's talk about some of the things we've got going here. Okay, to do that, let's head to our Attorney Steve whiteboard. We can get it back up here. Okay, so let's talk about a few things here. We are talking about your unpublished opinions and what this is, how this comes into play. You're doing your legal research. You're citing your brief, maybe you're improper or you're a lawyer, you're trying to bolster your case and you find the perfect case. You go, oh yes, here it is, I found it. And you're citing it and you're reading it and the language sounds so delicious and you just cannot wait to cite that to the federal court or the state court that you're in. And you get to the bottom, you make all your notes and you look back at the top and you see not certified for publication. And you go, oh my God, are you kidding me? This is the perfect decision. The judge has to see my legal argument. I have to get this in front of the judge somehow. Okay, so the real question is, can you get it in front of the judge? And what weight will it have? Will the judge give it any credence whatsoever? Or just say, what are you doing? And try to hit you with sanctions or something, okay? So be very careful when you're using unpublished, uncited cases. But let's talk about a couple things here on the whiteboard. First of all California Supreme Court, the Supreme Court of California, the Supreme Court of the United States, those cases are always going to be published, barring maybe some small weird exception of some sort. But in the for the most part, those cases are going to be published. You can always use United States Supreme Court, California Supreme Court cases. So don't worry about that. Check that off your list. Interesting point of fact, in California, roughly about 10% of the majority opinions, the cases, are actually published. So it's not a whole lot. Actually, there's a whole lot of cases that are not certified for publications. And one of the questions I get is, well, why isn't it published? It's the perfect case. You know, there are ways to apply to a court, to ask a court to certify it for publication. Sometimes parties can get together and say, hey, this is a really important decision on California law. It's really going to affect a lot of people. Certify this for publication. On the other hand, we've also had other cases that were certified for publication for example, the Glaske case was certified for, it's a wrongful foreclosure case. It was certified for publication. Banks didn't like it, so they came in and tried to have it depublished so that you couldn't cite it. So there's all sorts of worlds and things and arguments that could be made behind the scenes with opinions and unpublished opinions and things like that. So it's very important to understand not all decisions are published. Why is that? If you ask me, I'm not 100% sure, but I think because sometimes a court just wants to resolve the dispute between the two parties and not make some big overreaching law that, you know, some case law that everybody's going to follow. Like in a foreclosure case, if they adjudicate the rights of the parties, it's in favor of the borrower. You might have 10,000 borrowers rushing into the courts overnight. So it's floodgate litigation protection. That's the best of my knowledge. There's probably other reasons, but that's the best of my knowledge. So let's go back here. So not all cases are certified for publication. You can cite generally. When can you cite a case? Usually when it's issued for publication, you can feel free to go ahead and cite it. Now realize, in some cases, even though the case gets certified, usually there's a 30-day wait period before it becomes final, but also those opinions can be as you can see here on my chart, it can be superseded. There was a case that I just found that we were looking at, I was relying on, I looked at it, and I go, this is perfect, we've got him. This is the case law we need here. It says exactly what I'm saying. And unfortunately, it had been taken up to the California Court of Appeals, and it had been pulled up on review. So the opinion was basically on hold or superseded. So you couldn't actually cite it. It was actually becomes then an unpublished case. The Court of Appeals, if a Court of Appeals decides to do a rehearing of a decision, okay, then once again you could be citing a case that's up on rehearing and it's no good. So you want to be careful before you're citing cases. Look them up in Westlaw or LexisNexis, whatever you're using. I like Westlaw myself. I think it's way better, but I'm not promoting Westlaw here. But, you know, so some examples, these things may not be citable, okay? So you have to be thinking about that. Now, the other question we have is in state courts, you have your California Court of Appeals and different divisions, appellate divisions of your superior courts that are issuing these opinions, issuing opinions. As we said, 10% are being published, 90% are unpublished. Can you use these? Can you cite to these unpublished opinions coming from your state court? Can you cite to these unpublished opinions and cite them in your briefs? Your appellate briefs, your demurs, your motion, your other state court filings. Can you, and we already hit the sanction, so you got that down. Can you cite those in your case briefs as persuasive authority? Now keep in mind, when a case is not published, you're not going to get the persuasive authority that you want. That's what you're doing as an advocate. You're always trying to persuade the court that your opinion's right. So we're talking about persuasive authority here. Can you cite these unpublished opinions from other California courts in your California court case? Remember, in our system of justice, we have state courts, we have federal courts. Okay, so what I'm talking about now is taking an unpublished state court opinion and publishing it and using it in your state court case. Taking your appellate court case in California, using it in your California state court case. Okay, we got the rule here for you. It's California Rule of Court 8.1115. That's 8.1115. It basically reads, any decision that is not certified for publication or not ordered published may not be cited or relied upon by a court or a party in any other action. Okay, so that seems to be a pretty boilerplate rule. There are 3 exceptions. If the decision is relevant under the doctrine of the law case, the doctrine of the law, basically you have the same parties or same facts at issue in your current case, you may be able to get away with it. If it's relevant, or excuse me, if it's related to res judicata or collateral estoppel, we'll talk about those in a separate video, too much to talk about here. Or if it's relevant to a criminal or disciplinary action because it states reasons for a decision affecting the same defendant or respondent in another such action. So you have a couple limited exceptions. I'm not going to overblow them here. Look them up if they're relevant. But so that's 8.115. Now, if that rule says you can't, if you can't cite these, you want to be careful. You don't want to cite cases that are unpublished from the Court of Appeals or the Appellate divisions and citing those in your state court case, because you may get sanctioned. The judge may say, what are you doing? The other party's going to call you out and say, Your Honor, what are they doing? I want to seek sanctions against them. So bear that in mind. Those are your general rules. There is an article I read that I found pretty interesting, is whether or not, notwithstanding this rule, that you can come back and seek judicial notice of the case as it being an official act of another court. So bear in mind, for you legal scholars out there, you really have to get this argument in. Take a look at judicial notice and whether or not the evidence code overrules the California rules of court, okay? So I don't have time to go into the whole, there's a call now. I don't have time to go into the whole legal argument here, but that's something to look at if it's really a pressing issue, judicial notice. And basically, we do have authority that you can, in a state court, you can cite to your unpublished federal decision. So if you have a federal court decision and you say, I got to get this into my state court case, I've got to have it heard, there is some legal authority. That is you're going to have to bear in mind, that's my internet marketing there. So you're going to have to bear in mind the Halagowski versus Superior Court case. You may be able to publish your, you may be able to cite to your unpublished federal decision, okay? Halagowski talked about jurisdictions including federal courts, and so you, as this case talked about, you could get persuasive authority on that. So persuasive authority, unpublished federal court decision. Okay, so that's part 1. Stay tuned for part 2 if you want to hear a little bit more about the federal rules and how it works in federal court. Attorney Steve Vondran, hang with us.